even if we could envision a democracy where the independent state legislature doctrine will be enacted in sort of this good faith way, I think 2020 taught us that in the times that the doctrine came up, it was in undemocratic situations. Even in the 2000 election, when this doctrine was battered around as a potential response to what was going on in Florida, it was framed as, well, the Florida state legislature can sort of ignore the election and allocate the electors consistent with this doctrine, right? So, and at the time, it was still disputed who actually won that election. And so in that way, anytime you have a situation where you have a doctrine that could lead to election results being advisory as opposed to being binding, that's not a democracy. So if they adopt a maximalist version of this doctrine, it's a wrap.
The way that they have to process all of this constitutionally, kind of trying to create the rule against a system that, whether you agree with them or not, like I think most of them, probably the current membership of the court, probably don't think it is right. And it seems to me, for those who tend to think, have share a little bit more of the views that I'm usually litigating, I think most people think like it's an easier question that you can't have independent districting commissions than the question of whether state courts can enforce laws as to what the state legislature does. So you've kind of got them like in a backwards reverse order that just makes all of this a little bit unusual.